If you create great content, people are going to copy it. You need to accept that, and you need to be ready for that. And often what I'm going to tell you is that's going to mean you're going to accept it and move on. And so what I mean by that is if someone copies one of your blog posts, yeah, it stinks, but often it's not going to be worth your time, your mental bandwidth, or any concern for you to spend much time on it.
Get ready to build, protect, and sell your expertise online with the Online Genius Podcast. You'll laugh. We hope you won't cry, but you'll always be informed and prepared so you can have the success you want. Here's your host, Bobby Klinck.
Hey there. Welcome to this week's episode of the Online Genius Podcast. I'm your host, Bobby Klinck, and I'm excited for today's show because we're going to be talking about a topic that I hear online entrepreneurs talking about all the time. Even if they're not necessarily using this word, online entrepreneurs are definitely concerned with the issues about copyright law. It's an issue that comes up over and over and over again in discussions that I have and in groups that I see. And so it's definitely an issue that you need to understand. Copyright law is the area of law that is related to or would cover the content that you are putting out in your business, but also the content other people are putting out in their business. So it's an area that clearly relates to what you do, so you need to understand it. It's also an area where there are a lot of misconceptions. A lot of people get things wrong, and people often get these things wrong because there's what I call street law out there where they've heard this rule or this idea or this concept, and so I wanted to debunk those as well. But in today's show, we're going to talk about what is a copyright, what is protected, what are the rights you get with it, some common misconceptions, some areas of concern, and then what you need to be doing to protect yourself and your content. So that's what we're going to be talking about today in today's episode. So it's definitely related to your business and something you need to understand. So let's go ahead and dive in. Now, first, what is a copyright? Well, a copyright or copyright law, just to give you a sense, it is the area of law that is generally going to extend to just about every aspect of your online content, your lead magnets, the products you're selling, etc. Because copyright law is all about protecting creative content. And now here, when I use the word creative, I don't mean that it has to be the next, Great Gatsby or some great work to be creative. No, it just has to be something where there's some spark of creativity. So a simple list of data isn't protected. And the reason why, this is kind of an important concept here, is that copyright doesn't protect ideas and it doesn't protect information. Copyright law comes into play and protects a particular expression of an idea. So what does that mean? Well, it protects things like a written work, right? It's not the idea behind your novel or your blog post or any other written work you're putting out that's protected. It's the actual way you put it out there in that written work. So let me give you a kind of easy way to understand this because I'm talking about written works here. So if you think about it, in the online marketing world, a lot of the same advice is being packaged by different people in different forms and in different formats. So there are countless blog posts about SEO, for example. Well, that's just the nature of the beast. And again, the concepts that are taught in those blog posts will often be the same or very similar because, look, SEO, there are certain concepts that are going to apply to search engine optimization every single time. It's the rules of the game. And so the advice, the information, the education, the concepts are going to be the same. That you can't prevent someone else from using. But what copyright says is, hey, if I package it and express it in a certain way, you can't take that way of expressing it. So, very simply, You can't go grab my blog post, copy it, and then put it on your site. That is not allowed. And this is not just about written works. It applies to other areas of content. It applies to music, to dramatic works, to images, to pictures, to graphics, to sculptures, to videos, to podcasts and other sound recordings. And then this is unlikely to apply to your business, but copyright law also attaches to architectural works. But it does have some relevance there when I talk about this copyright issue, because if you are using a picture of a famous architectural work, you have to make sure that you have the permission to use that architectural work. So that's something you have to think about. But so that's what's protected, generally speaking. And now let's talk for a minute about what rights come with a copyright. Because you say, okay, well, copyright law protects that. Well, the person who holds a copyright, and just so you know, that will generally be the person or company that first published a work, created the music, etc. That person has the exclusive right to reproduce the work, to distribute copies of the work, to perform the work publicly, to display the work publicly if it's art or something of that nature, and then also to do what's called preparing derivative works. And that is something where you take the existing work and, kind of create a derivative from that. So that's something slightly different, a new variety. Think of it like that. So those are the rights that the copyright holder will have. And what that means is you cannot use someone else's copyrighted work. You can't make a copy of it. You can't reproduce it. You can't distribute it. You can't display it, etc. Only they can. And a concept here let me help you understand a difference here, and an issue that applies here in the copyright world is that this may help you understand it. If you buy a painting, you have a right to own that particular painting and to have it in your house, etc. But you don't have a right to make copies of that painting and sell prints. No, in fact, the copyright holder, usually the actual person who originally painted the work, is the one who has that right. So that's why you'll often find that there are prints of famous paintings. And again, the more modern paintings this applies to. You're going to have those sold usually by the actual artist or their estate or someone associated with them. They are the ones who have that right. So that's the issue of artwork, but let's think in the terms of music. When you buy music and you have it on your iTunes, you own that copy to listen to it. But you don't have the right to make a copy of it and sell it to people or etc. We all know that from the Napster case, but you might also know it from the movie world where we used to see these, and I guess you still do on Blu-rays, you see the FBI warning at the beginning of a movie that you can't make copies of it because copyright law protects that. So that's the bundle of rights. That's what's protected generally by copyright law. Now, the next question is, how do you get rights as a copyright holder? How do they come about? What do you have to do? And the good news is here for you. You don't have to do anything. The minute that you create a copyrightable work, you get protection. The legal test is that once the work is in what's called, quote, fixed form, you get protection. Now, that means for all intents and purposes, let's talk about your blog post. When your fingers leave your typewriter or your keypad after having written the post, it's then in fixed form and you get protection. The same thing if you create a lead magnet. The minute that you have put it all down there on a piece of paper or a PDF or whatever you're doing, that gets copyright protection. The minute I finish recording this podcast episode that I'm currently recording and hit stop, I get copyright protection because it's in fixed form. I don't have to do anything. You don't have to do anything to get those rights. They come up automatically. Now, here's the great news. That's not just in the United States. There is a convention that's been signed on to, I think now something like 190 different countries have all agreed to this. And the rules of that convention are that you get protection automatically. So almost everywhere in the world, you get protection the minute you publish something. So you don't have to worry about doing anything anywhere else either. Now, that's the protection you get automatically. But here in the United States, you can also file to register your copyrights. We have a copyright office that allows you to do that. That's kind of an extra step that you can go through to get protection for your works. Now, why would you go through the step of registering a mark or registering a copyright if you get protection automatically? Well, there's a couple of reasons. Just so you understand, before you can sue anyone for copyright infringement here in the United States, you have to register your mark. Now, you don't have to register it initially. You could wait, and then if someone steals your stuff, you could go register it then and sue them. You can do that. But before you could actually go into court to try to enforce a copyright, you're going to have to register it. That's just kind of the legal requirement. There are some advantages to you in a dispute that comes up later if you took the time to register it at the beginning. Now, the reason why, there's a couple of different advantages that can come. Number one, you can collect what are called statutory damages. So you don't have to actually show that you've been hurt or harmed. You can just get automatic stuff and go ahead and do that. So you will get that extra benefit. You can also get some presumptions that things are valid and that you are the author, etc. You can get some attorney's fees and things like that. The point, though, is that almost all of the protection that you are going to get by registering comes into play in the case of a dispute where you go to court. And so that's why I like to tell online entrepreneurs that registering a copyright doesn't need to be a high priority, because chances are, that you're never going to find yourself in this situation. You're never going to be suing someone for stealing a blog post. And because of that, it's not something that really needs to be on your, hey, I've got to get this done now. And so that's my general guidance on that. Now, if you decide to do it, you basically go to the Copyright Office website. You go to copyright.gov, and it's a pretty self-explanatory process. The fees are somewhere between $35 and $55, depending on what you're registering. And then you'll have to deposit either one or two copies of the work with the Copyright Office. So it's a pretty straightforward process. Now, I'll just give you, my perspective on this. I'm an attorney. I'm an IP attorney. I produce lots of content. The only things that I've ever registered a copyright for are some books I've written. And I don't know if I did one or two, and that was because it was included in the Create Space service. I just said, yeah, I'll do that. And so they went ahead and registered the copyright for me. Now, I don't know about you, but I don't expect to be suing people anytime soon. And so because of that, I just don't think that it's necessarily worth my time, energy, and money to go through that process. So that's my thinking on the registration. Now, if you have a signature course, it might be worth doing. If you have a book, it's probably worth doing. If you have those kinds of things, it can be worth doing. But understand that largely in registering it, what you're doing is setting yourself up for benefits in a later dispute that you might have. So that's the how you get protection. Now, another issue that comes up and that people are unclear about on copyright law is, do I need to give notice to people that my work is copyrighted? And often this will come in the reverse situation of, how do I know if someone else's work is protected? Well, the answer to that is that you are not required to give notice that your work is copyrighted. Now, it used to be the case that you had to. Before, I think, 1978, you had to put a copyright notice on a work or you would lose protection. And then there was this interim period between 78 and I think 89 where sometimes you had to and sometimes you didn't. But now you don't have to. You don't have to put a copyright notice anywhere on a work to protect it. You get protection automatically, no matter whether that's there or not. Now, that being the case, you should put a copyright notice on things. And the reason why you should is because a lot of people don't know that you get protection automatically. So a lot of people might see a website, and if a website didn't have a copyright notice, think, oh, well, I can use this. Or if your lead magnet doesn't have a copyright notice, they might say, oh, well, I can just copy this. Now, they can't legally, but they might think that. And so by putting a copyright notice on something, you will often just put them on notice and make sure that they understand that they can't do that. And so that's the big part of the value in putting that notice, is that it makes sure that they don't wrongly think they can use it. But so that's for protecting your own stuff. But I do want to step back and help you understand. You need to assume that any written works, any images, any pictures, any recorded audio or video or anything like that you find anywhere else online is copyrighted, and that you can't use it without permission. And we're going to talk about that in a second, about what that means and how you get that permission. But that needs to be your going assumption here. So that's where you should be. Now, I want to address now an issue that may be a bit in the weeds, but I have to address it because it's an issue that I hear come up over and over and over again. Now, you may hear this concept and say, I don't even know what he's talking about. I didn't think that. And if so, good. But I want you to understand this. There is a concept in copyright law called fair use. And what this means, what this concept basically says, is even for a copyrighted work, you can make a, quote, fair use of that work without having to get permission, without having to pay anything to anyone, etc. The problem is that too many people think that this is kind of a cure-all that will protect you and means that you can use stuff that is copyrighted much more broadly than it actually means. So what I want to tell you is you should not assume or believe that you can use someone else's copyrighted material because of fair use doctrines. You generally should assume you shouldn't be able to. Fair use comes into play, and there's a number of factors that are applied. But the types of things that are clearly a fair use of a copyrighted work are using a small excerpt of a work in a review or a criticism, right? So in a book review, if you pull out some language in a big, long book review, but the whole point of the thing is to review the book and you're explaining your thoughts, etc., that's going to be allowed. Parodies and satire, that is allowed. So you can take a copyrighted work and make a parody of it. Quotations from a speech or event in a news report, those will be allowed. And limited copying by a student for academic work will be allowed. But what this doesn't protect generally is you or I making broad use of someone else's work for our commercial purposes. When you are doing something for commercial purposes, like we are, so using something in our business, that is generally going to be a big strike against you in terms of it being a fair use. And so you generally should assume you can't do it. And let me give you an example of where people seem to think that they have a get out of jail free card here. You may have heard of something, I call it the 7-second rule, but I've heard it in all different variations. Some people believe that if you only use 7 seconds of a song, that's okay. Or it might be 5 seconds, some people say. I actually heard someone say up to 30 seconds they believe. That you could do that without a problem. You can't. Let me just be clear on that. So I could not take 7 seconds of, a popular song and put it as the intro to this podcast. Not allowed. There is no magic number that says less than this number of seconds is okay. That just isn't the case. And so you have to assume that these copyrighted works, music, videos, written works, etc., are protected and you can't use them without getting permission. So if you hear someone start talking about, oh, well, that's a fair use, you can do it under the fair use doctrine, you should be afraid. Because there are lawyers who spend their entire careers making a living fighting over what constitutes fair use. And so it's not something that's going to save you and kind of be a get out of jail free card that you should assume. So now that we talked about that, let's talk about what's allowed and what's not allowed. And first here, we're going to let's talk about how we keep you out of legal hot water that relates to copyright law. So basically, let's talk about what you can do first that you don't have to worry about, okay? Number one, you can reference other people's work or material. You can direct people to it. You can put links to it. You can do anything and any of that kind of stuff where you're referring or sending people to do it. In a course, for example, you could have them do assignments from other work. So, for example, you could say, go take the Strengths Finder test in the book. Or you could say, go take this assessment that is offered somewhere else. That is all fine. When you're referring to something, etc., not a problem. Now, you can also take inspiration from other people and can even mimic the structure of their content. So you maybe have heard the concept of funnel hacking. Well, this is a common thought in the online entrepreneurship world, and it makes sense. Don't recreate the wheel. Go see what other people are doing, get inspiration, and maybe follow that same structure. So you all know there are, say, only really 5 to 10 different webinar structures out there that are used over and over and over again. And you can do that. You can watch someone else give a bunch of different webinars and say, okay, I want to model their structure of how they go through the slides and do that, as long as you're not copying their content. And again, you can include the ideas from someone else, just not the particular expression of the ideas. So what does that mean? Well, let's say you are going back to the SEO example that I talked about at the beginning. Let's say you want to write an epic blog post about SEO for online entrepreneurs. Your first step is probably going to be, you probably know this stuff, but maybe you're going to go out and do some research and see, well, what did, this person say? And what did that person say? And what are they saying? And maybe what you're doing is, this guy's got 3 tips and this guy's got 4 tips and this guy's got 7 tips and this lady's got, 18 tips or whatever the number is. And then you're going to put them together into a definitive guide. As long as you're not copying them, but you're taking it to say, yeah, I should cover those steps. Oh, yeah, I should cover those steps. And doing that and putting it together, you're okay. Because the ideas are not protected. It's only the particular expression. Now, what's not allowed? Well, you can't copy directly or distribute someone else's work. So, in the blog post idea, you can't copy this tip number 5 from someone and paste it into yours. You can't do that. You have to write it yourself. You have to express it in your own words. Now, that kind of gets you some sense of what you can and can't do. But again, structure is fine, mimicking ideas, getting inspiration, all of that's allowed. What's not allowed is taking a direct copy and using it, either using it just in written works, putting it into your content without attribution, but even with attribution. So, for example, I can't take a copyrighted image and put it on my website. We're going to talk about that in a second without the right permission. Even if I say this is so-and-so's image, not allowed because it's copyrighted. So you can't make a copy or distribute it. That's what you're not going to be allowed to do. Now, about written works, this is an issue that comes up quite often. There's a couple of questions that people ask here. One is, how close is too close? Because copyright doesn't only address exact copies. So literally a cut and paste of the entire thing. If you cut and paste, let's say 1,000-word section from somewhere, and let's say you changed every, 50th word or something, that's not going to protect you from copyright infringement because you've copied it. Now, you've heard this in the press and news, et cetera, about plagiarism where they do analysis, et cetera. And so people ask, well, how close is too close? And, there's not a hard and fast rule. I can't say you do an analysis and if more than, a certain percentage is the same, you can't use it. There's not that kind of rule. But what I would tell people, the best way to avoid this being a problem is don't copy someone else's work and then try to edit it. In other words, don't do the copy, paste, and then try to edit. Start with a blank page when you're crafting the written works. Now, you can be looking at other people's work, but start with a blank page and type it yourself. Generally, when you do that, that's going to prevent you from ending up with something that's just, really mimics theirs, because you're putting it in your own words. You're going to put your own voice. You're going to put your own spin. So that's the best guidance I can give you on a way to do this. And again, there's not some rule I can give you that's absolute. Now, the other issue people ask me about all the time are quotes, inspirational quotes, etc. Now, copyright law does not protect short quotes generally, because there's only so many ways to say a certain thing. So there's only so many ways that you can construct an idea if you're talking about, let's say, just a 5-word phrase. So because of that, those little short phrases often aren't going to be copyrighted. Again, the problem is there's no hard and fast rule on what that is. What is the number where all of a sudden you get, it's okay to use and not okay to use? And the answer is it's not clear, but let's not go overboard. So, you could look at some book publishers. I think I was looking at Simon & Schuster has rules for their authors when submitting things. And I think they said that you have to get permission if it's more than 60 words. And I could be getting that wrong. But in other words, if the quote is more than 60 words, they want you to go get permission from the original copyright owner to use it, because they're saying, hey, at that point, you're using a lot. And this gives you a sense. This is even quoting a work that, you're going to quote and give attribution for, because at some point you can't use too much of it. So you have to be careful with it. Now, I've never heard of anyone having, some big name entrepreneur come after them for these inspirational quotes that we all see on social media. And I don't think you have to worry about doing that. Just be careful about doing it too much. So that's the written work. Again, I'm going to assume you're not going to knowingly go out and just copy someone's stuff and use it and et cetera. So that's not a real problem. But I do want to address an issue that some people also don't think about. Now, if you are, for example, a copywriter, not this kind of copyright, but the other kind, someone who writes copy for people, and you wanted to create a course and you wanted to show examples of good copy. Well, if you were to take someone else's copy without getting permission from them and include screenshots of it in your course, for example, guess what? You're infringing their copyright, because you are making a copy of and then distributing copies of their work, which is protected. So you have to be careful about that. You need to get permission before you do that. You might think, hey, I'm praising it. It doesn't matter. Even if you're praising it, you have to get permission before you can use it. Now, other areas that you have to think about that can come up are some areas with coding, et cetera, that can be protected. Just be careful. Be careful about copying anything and using it. You might get yourself in trouble. So that's written works in a nutshell. But now I got to shift focus to an area of copyright law that actually gets online entrepreneurs in more trouble than any other area of law. It has to do with the copyrights on images. An image has a copyright and it's protected. And that image is protected even if it's online, even if it's on social media, even if someone else used it on their website, even if someone else used it somewhere else, it's protected. It's protected by copyright law, and that means you can't use it unless you have the right permission. And this is where people will get into trouble. They do what I like to call the right-click save as problem. They see an image they like, and so they right-click on that image and then save it as an image to their desktop, thinking, I'll use it in my content later. If you do that, you have committed copyright infringement, almost without question. Even if it's an image that you could actually go get a copy of legally without having to pay for it, doing this right-click save as will generally be a copyright infringement. Now, they might not come after you, but it will generally be a problem. What you need to do is make sure that you are only using images on your website, in social media, in every other part of your online platform, if you have the right kind of permission, and it's called a license to use it. And we're going to talk about that in a second, about what a good license is, because it'll apply to written works, to images, and then to the other issue we're going to talk about next, which is music. But you'll need to get a license to use any image. And that means you need to go to reputable websites that actually have the ability to let you download stock images if you're going to use them. So make sure you do that right, or you can get yourself in trouble. If you don't, what will happen is you will get a letter from the copyright holder, often demanding $500, $750, $1,000, multiple thousands of dollars, depending on who the copyright holder is. And if you did it, you come to me, I'm going to say there's not much I can tell you other than you're going to have to pay them. And so it's a mistake that comes up over and over again. And so you need to avoid that one for sure. Now, the last big area I want to talk about before we talk about kind of licenses that I mentioned, what are the permissions you need, are music mistakes. Now, a lot of people don't realize that, or don't think about the fact that music is protected. And I think we know it inherently, but people somehow think that if they've bought the music, they can use it for whatever purpose. You can't. When you buy music, you do not have the right to distribute it, to play it, etc. So let's talk about what that means. You can't use the music that you've bought for your own personal use for your intro or outro of a podcast. You can't use it in your course. You can't use it in kind of a promo video you've made. And you can't use it on a live on Facebook or Instagram or any other social media network. When you do that, you are distributing the work without permission. Now, I can already hear you say, but other people do it. I don't care if they did it. It's not allowed. Now, you can do it if you want to take that risk, but you are violating copyright law if you do it. Now, the better bet is just don't do it. And this means don't play music on your Facebook Lives. Again, I've seen some big name entrepreneurs do it, and I cringe every time. I say, don't do that. So I would be very careful about it. I'm very careful anytime I'm shooting a live video not to have music playing in the background, not to have my assistant playing music in the background that you might hear, not have, when I'm doing it at home, my wife playing, from our Google Home speakers playing music in the next room where you might hear it. Just don't do it, because that's a problem. So you need to avoid those issues and make sure that you don't have those, that issue. And what I'll tell you is, there are stories about this happening where people have their ability to do Facebook Lives revoked because they are constantly using music. So you just need to avoid doing that. So with that, then you're probably saying, okay, fine, that's what I can't do. What do I do? How do I go get this stuff? If you want to use any of this material, and this really is for images and music and written works, if you want to use extensive amounts of written works from someone else, you're going to have to get what's called a license. That's the word we use when we're talking about copyrights and other areas of intellectual property for permission to use it. And what you need to do is you need to look for certain things in your license. Number one, you have to make sure that the license you get allows for the commercial use of the image, the music, etc. And this is a particular issue you have to look at when you're working with certain apps. A lot of apps or software as a service program will have a free option where you're not allowed to make commercial use of what you create. I've forgotten which one. There was one of these video kind of systems you could make, not animated, but somewhat animated videos. And I noticed that their free version did not allow for commercial use. And so I had to keep telling people, hey, by the way, you can't use that. So you need to look out for those things. That's kind of a common theme there. The free version you can use, for example, for creating, an invitation to your kid's birthday party, but you can't use it for your business. So you got to look out for that. So it has to allow for commercial use. The second element you want in a license is it needs to be royalty free. Now, this doesn't mean it's free. You might have to pay something, but what royalty free means is you don't pay based on the usage. In other words, let's look at an image. If I get an image, even if I pay for it and pay $50 for a license at the beginning, I get to use it, and it doesn't matter how many people look at it, how many people download this, etc. I have the right to use it for an unlimited number of impressions, etc., because you don't want to find that something goes viral and then all of a sudden you owe all of these fees to the image, someone who you use their picture on it. So it needs to be royalty free. Then the last element you're going to want to look for in a license is that there is no attribution requirement. And why you want to look for this, and this is really with images is the big place where this comes up. If the license requires attribution, what that means is every single time you use that image anywhere, you're going to have to disclose who owns the copyright for that image. And if you miss it once, you've infringed the copyright. And I don't know about you, but I don't want that administrative burden of having to remember that every time I post an image and every time an assistant, a VA, a designer, a social media manager posts an image from my catalog. I want them to just be able to do it and us not have to worry about that. And so make sure you do that and make sure that there is no attribution requirement on any image or music you get. Now, I use a few different sites repeatedly. There's a freebie that you can get, which is my stock image guide. And you just go to youronlinegenius.com/stock image, and you'll be able to get that guide. I walk through these attributes of a good license and then a dozen different sites where you can get access to stock images that meet those criteria. So make sure you grab that if you don't have it yet, because I know that's something that's important for folks. We need to be able to get images quite often. So I went ahead and went through the licensing terms of a dozen different sites, and these are good and you can use it. So you want to get in the practice of getting your music and getting your images with these licenses in the right way. So that's kind of how you stay out of hot water by making a mistake. Now, let's transition to how you use copyright law to protect your work, to, avoid pirates from stealing it, etc. Now, I want to give you a point, and I want you to accept some reality here. If you create great content, people are going to copy it. Let me say that again. If you create great content, people are going to copy it. You need to accept that, and you need to be ready for that. And often what I'm going to tell you is that's going to mean you're going to accept it and move on. And so what I mean by that is if someone copies one of your blog posts, yeah, it stinks, but often it's not going to be worth your time, your mental bandwidth, or any concern for you to spend much time on it. Because what are you going to get out of it in the end? So you have to think through those things. But let's talk for a second about what you should do, the steps you should do to protect things. So the first thing we talked about, you can register works. For your really important works, you should probably think about registering them. So if you have a signature course, you should consider registering a trademark for that course. If you have a book, I would register the copyright for the course. The same thing with a book. If you have a book, I would register the copyright for that book. If you create a movie, you should probably register a copyright for that movie, etc. So you should think about doing those kinds of things for your signature works. Second, you should use copyright notices even though they're not required. Like I said, they're not required, but it's a good practice. That way you're putting people on notice and making clear to them that you are saying this is protected, they can't use it. Third, protect any online programs and other content that you put out into the world, freebies, etc., with agreements and terms of use that limit what people can do with it. So, on your freebies, they should be protected by your terms of use for your website, and that should say that they can't use it, except in XYZ circumstances, and that they can't copy it, etc. The idea behind that and why you want to actually put that in a term is all of a sudden you have a contract term, not just a copyright right. You have a right under this contract you have with them to prevent them from doing certain things. So that can have some value. And the same thing with your course. If you have an online course that people are paying for, you should have program terms that lay certain things out. Among other things, it's going to say that they can't copy it. So do those kinds of things because that's kind of a common sense protection. But again, even after you take all those steps, if you are creating great content, it will be copied. So what do you do? Well, the first thing you're going to want to learn is the DMCA. It's the Digital Millennium Copyright Act. Now, what this is, to give you a quick backstory, it was a law passed back in 1998, back when, the World Wide Web at that point really was the wild, wild west. And Congress wanted to try to strike a balance because there was rampant copyright infringement back then online, and they were trying to figure out what to do. And so they wanted to protect copyrights. But at the same time, online companies that were hosts and bulletin boards, et cetera, they were concerned saying, hey, we're not the ones posting this stuff. We shouldn't be held liable if one of our users posts stuff. And so what happened was Congress struck this balance. And it says that a company that hosts third-party content will not be held liable for copyright infringement so long as they have a policy and they act in response to getting notice that someone has posted infringing work on their site. So think of this in Facebook. If someone is copying your content and putting it on Facebook, Facebook isn't the one putting it up. And so a company like Facebook, but also your web hosting company, all the social media sites, all of the reputable online course hosting sites, etc., they have policies that says, hey, if you believe someone else is infringing your copyright, here's what you do. And they will tell you how to send a notice to them. And if you demonstrate to them that someone is using your copyrighted work, they will take it down. They will take it off of their site. So that's going to be your best bet because you don't have to go to court. You don't have to do anything. What you have to do is follow their procedures, give them the right notices, give them the proof to show that what the other person is doing infringes your content, and then they do everything for you. So that's a DMCA takedown notice is what that's called. So if you find someone is infringing your content on a social media site, or any other website, what you're going to do is go to their terms of use, their terms of service, that the hosting company, and just do a search for DMCA or takedown or something like that, and they will have procedures for what you need to do exactly to meet their requirements. But that is your best friend. Now, what happens if you can't get it taken down for one reason? Maybe it's being hosted, offshore, or maybe it's being hosted personally. Like let's say I had a server and I was hosting my own website on my own server. You're not going to be able to go to any third party. Should you call a lawyer? Should you actually pursue it? Now, I'm a lawyer and I used to be a litigator and do a bunch of these disputes. What I will tell you is it usually will not be worth your time to try to pursue people who are infringing your copyrights. Now, it might be worth going to a lawyer to send a cease and desist letter. Beyond that, though, it's normally not going to be worthwhile. And the reason why is lawyers are expensive. And let's ask yourself a question. What of your material, what of your work could you show damages in the tens of thousands of dollars because someone's stealing it? That's the first thing. You got to be able to say, hey, I'm going to be able to show enough damage that it makes sense to pay this lawyer. But even if you could show that, there's a second level problem. Are you going to actually be able to actually get any money from the person, even if you win? Or are they what's called judgment proof? Oftentimes, the people who are doing these things, copying your work and selling it as knockoffs, you're never going to get them. Even if you won a case, you would end up spending years of your life trying to chase them to get some money, and you're not going to get it at the end of the day. And so that's why I tell people often it's not worth your while. It's not worth your bandwidth. It's not worth the concern. Instead, your time is usually going to be best spent just saying, hey, it sucks that they stole it, but I'm going to keep going. Now, if you have a really high ticket product and someone is definitely in the United States and you know they have resources, it might be worthwhile. But generally, you're going to need to accept that it's not going to be worth your while. And I know that's weird to hear from a lawyer, but it's just not going to be worth it in most cases. And so I give you that, but you can talk to a lawyer. Most lawyers will be willing to consult with you for 30 minutes without charging you to see if you have a case, and you can give them some sense and maybe get a sense of whether it's worthwhile. But the answer is going to be most times it's not. And what I'll tell you is I work with some entrepreneurs who are, established, and they don't even pursue these things just because they know it's not worthwhile. And so the viewpoint I look at is, hey, if someone is going to buy a knockoff of my membership site, for example, from somewhere, and it's clearly a knockoff, they were never going to buy from me anyway. I mean, this is not someone who was ever going to come and be my customer, my client, and that's going to be the case most of the time. So I would generally tell you that it's not going to be worth your while to worry about these things, so try not to, but take the basic protections that we talked about. So, consider registering, use the DMCA, put copyright notices, etc. Let's try to prevent as much infringement as we can at the outset. But if it's happening, you're probably not going to do much beyond a DMCA takedown notice. So that's what you're going to do to protect your own content. Now, we've talked about a lot today, and that's kind of the end of this podcast episode. We've kind of covered copyright in a nutshell in about 45 minutes, which is hard to do. So if you have questions, feel free to reach out. But the idea is this is giving you a good primer on an area of law that you really do need to understand. And the highlights are, again, anything that's in your platform is protected by copyright, but also every element you're putting into your platform that someone else created, they have copyrights in it. You generally can't use it without permission. And you should not expect some, limited use exception or anything like that to come in. So you're going to need to get protection. Be careful with images. Be careful with music. Make sure you're doing those things and you'll be in good stead. Now, other than that, it's going to be just use some common sense and don't copy, and be careful about that. And if you do that, you'll be in good shape. So that's it for this week. If you're enjoying this, again, I have an ongoing training, Legal Made Simple, that you can register for, where I kind of walk through the basic building blocks of what you need to do to protect your business. You can register for that at youronlinegenius.com/webinar. And I walk through and really give you some advice like we're doing in these series, these mini trainings, and really help you understand what you need to be doing. You get about an hour of really in-depth training with some visuals, which maybe is helpful for you to be able to kind of see some things, not just hear me talk about it. So if you're enjoying these mini training series, go ahead and sign up for that training. You can go to youronlinegenius.com/webinar. Until next week, this is Bobby Klinck, and I will talk to you then.
Thanks for listening. And remember to visit mistakes.youronlinegenius.com to get your essential guide to the 4 legal mistakes that can doom your business and how to avoid them. Join us next week for another episode to expand your online genius and your success.